Alright, Federal Road Administration Track Safety Standards Compliance Manual, Chapter 4, Exemptions to the Standards, January 7, 2008. Exemptions to the Chapter 4, Exemptions to the Standard, Introduction, Title 49 Code of Federal Regulations, Part 213, Track Safety Standards contains the minimum requirements of safe track of the roadbed. Railroads must comply with many of the separate requirements contained in the Track Safety Standards. If the railroad deviates from these requirements, the train operates continue without appropriate remedial action considering enforcement action. Each situation contained with a multitude of factors as such, an inspector must exercise professional judgment guided with the law and with the enforcement discretion criteria set forth in Title 49 CFR Part 209 Appendix A, Statement of Agency Policy concerning enforcement of the Federal Railroad Safety Laws. When deciding whether to recommend legal action for compliance within the track safety standards, among these criteria are inherently seriousness of the condition of action, the kind of the degree and potential safety hazard condition of action poses in light of immediate factual situation, the general level of the current compliance with the recent history of the compliance. The chapter will assist the inspector in making enforcement determinations by providing guidelines assessing seriousness of any of the defects that specifically contain context of the track safety manners of the condition with observed during the particular inspection and promotes the FRA policy for the focused enforcement. The FRA's limited enforcement resources to assist the most serious persistent compliance problems. The FRA primarily purposes to carry out the intent of the Congress as stated in Federal Railroad Safety Administration, Federal Railroad Safety Act of 1970 to promote safety in every area of the railroad operations, to reduce the railroad-related accidents and incidents, improve the safety performance achieved by the adherence to prescribed standards, accomplish the objective, therefore obtaining compliance with the track safety standards, defies the purpose of the action. Purpose of the act, it was necessary to improve the compliance with to reduce the risk of accidents in a particular situation. This should be the primary factor to determine the enforcement action, such as the imposition of several penalties. Inspector can initiate the enforcement actions of the various types of the use of the individually in combination the enforcement of the tools available in order to increase the severity. Are defective report field 97. Form 97, Defective report field 6180-96 or Form 96, the violation report recommended civil penalty Form 6180-111 or narrative report, special notice for repairs, slow to order, compliance, and other recommendation notice of the track condition emergency order. Each inspector should prepare the purpose of the safety laws with the track safety standards enforcement activity to reduce the train accidents and casualty property damage resulting in defective conditions track roadbeds, whereas adherence to the requirement of the track safety standards will help lessen the risk of the track cause accidents. Inspectors must be able to distinguish and verify the levels of safety presented with the violation different standards. Each of the conditions identify the track safety standards different and act of the performance of the track structures in accordance with the different conditions, heavy, widely verifying the effects, immediate hazards of the train operations. For the example, the most cause of the broken railway presents a great immediate hazard to the train, therefore vegetation adjacent to the roadbed. When determining whether 5 enforcement actions pursued, the inspector considered with the risk of the accidents presented with the defect itself. In addition, the inspector must consider the possible consequences of the accidents caused by the condition with the railroad representative knew the defective condition existed, but the previous track caused with the adjacent performance on the particular rail line. The railroad track standards compliance program train speed with the particular location, type of the traffic handled on the line, the hazardous material, passenger population, proximity, and the terrain of all influences the sequences influence of the consequence of accidents. Deficiency reports. All enforcement activity begins with the inspection, during which the inspector will record all the defects of the Form 96 of the C Chapter 2 of this manual for instruction. Defects of reporting the constitutes the most frequently used enforcement action, may allow the groundwork for the more severe enforcement action. If necessary, exercise to conduct with thorough inspection, recording the location, type, and the size of each of the defects discovered, whereas the defective report is usually sufficient to bring with above out the compliance with the inspector must remember that every defect of the report may become the violation report if defects remain. It is operable that these reports are legible and accurate and complete. These description locations are each defective and should be concise enough of the person not present during the inspection could locate the defects. Sound the performance during the inspection report ensure the sound legal action in the future. Violation report. In the 1970s, 1980s, the railroad industry experienced a significant reduction in track-caused accidents. In recent years, the trend has leveled off, but the number of the rails and rail joint type of the track-caused accidents increase. Therefore, it is important for the inspectors to use all the enforcement tools, including the track violation, to help ensure compliance. If the responsibility of the regional supervisor or track safety specialist to ensure effective violation reports utilization, a defect is the condition not compliance with the track safety standard. Defects noted with the inspection report serve as notification of the railroad of the FRA awareness of the defects existent with the defects may also serve as evidence of the railroad knowledge of the defects. Such see the discussion below. The knowledge of the standard. The FRA inspector may choose to also recommend the civil penalty violation defects. So note the decision on the inspection form. The violation serves the two purposes. One, notifies the railroad with the FRA has concluded that the condition does not completely does not comply with the track safety standards. Two, notifies the railroad that the inspector has reviewed the circumstances associated with the condition and non-compliance and its recommended civil penalty. In many cases, documentation conditions are not compliance sufficient to achieve the compliance with the track safety standards. However, there are many instances where the condition warrants a violation. Recommendation violation, inspector must prepare a well-documented narrative report describing the series of the condition. One of the inspectors has determined the civil penalty should be recommended. Also, facets, conditions, circumstances must carefully considered to be judged as the degree of the violation. Any person in C Title 49 CFR 213.15a, the definition of a person who violates or causes violation of any of the requirement of Part 213 is subject to civil penalty at the least $500 up to $11,000 per violation. A penalty is not exceeded with $27,000 may be assessed under the conditions of Statute 213.15a. Therefore, the inspector must present the facts of the situation narrative report. Recommendation for prosecution should leave in no doubt with the degree of seriousness of violation. The inspector should be aware of that within the penalty amount normally assess a particular violation under the penalty schedule of Part 213 C Chapter 5 Appendix B, the defect and code penalty schedule. In circumstances seem to warrant higher potential penalty or assessment penalties, the multiple days of the violation continued, the inspector should discuss the factors of the regional specialist. If in both areas the extraordinary penalties are appropriate, they shall prepare the cover of the memorandum of the regional manager to send the FRA office to the chief of the council. The memorandum should explain the factors of the warrant that higher than the normal penalties and or assess the multiple days with what amount of the recommended assessment would be, and explain why such extraordinary assessment need is in this situation. Alright, knowledge standards 213.5 requires that any of the track owner who knows and notices that the track does not comply with the track safety standards must bring the track to compliance with the whole operation over the track. The knowledge of the standards has been in the track safety standards since the creation. The FRA decided to retain the standard of the revision of the track safety standards in 1998. The standard holds the track owner liable for violations of which actual knowledge of which would have been known if the operator has exercised reasonable care, the violation of which the constructive knowledge. This standard is thoroughly discussed in Preamble 1998 final ruling found in 63 Federal Registry 33992 or 33995 through 96 and 1998. In submitting the violation report, the recommended issuance of civil penalty, the inspector must finally fully support the conclusion of the track owner as the actually constructive knowledge of the defective time when the operation is required occurred with the track. One of the establishing actual knowledge of the inspector to record and notify the track owner when the defect is found. Re-inspect the laters to see that the track owner has the track appropriate remedial action. If the track owner has not taken appropriate action, the inspector should cite the track owner the violation with the track safety standards. Another method of demonstrating actual knowledge is to show the defect has been noted in the track owner's inspection records, including records automated inspection demonstration actual knowledge, and the violation reported should clearly trace each defect to a specific item in the FRA inspection or railroad inspection records. Additionally, a citizen's complaint is concerned directed to the railroad would fulfill the knowledge standards. In some situation, the defect has been noted that the previous FRA inspection reported the railroad-owned inspection records. Citing should be a defective violation required of the inspector demonstrated with the track owner constructive knowledge. Establishing the constructive knowledge of the defective requires the proof that the track owner would have known the defective if the owner had conducted the previous inspection with reasonable care. The track owner cannot simply wait for the FRA to provide with the notice of the defects of what the track owner should find. The track owner duty that inspect the track with given the notice of any defects should be required, and the inspection would reveal whether or not the railroad detected it. When the demonstrator of the constructing knowledge, the civil penalty recommended by the inspector should attach a copy of the railroad last and the required report inspection. The inspector should explain why the defect of such a nature that it would have to exist at the time of the last inspection. For example, the cross ties generally deteriorate slowly over the time, so cross ties condition found by the FRA or state inspector probably was defective when the track owner was last inspected the track. Simply rust on the surface of the component would be exposed to the moisture only when the non-compliant conditions on the broken surface of a joint bar may demonstrate that a defect must have been existed at the time of the last inspection. Criteria affecting the seriousness of a non-compliant condition. The non-compliant condition under one of the circumstances may warrant a defect, while the same condition or the different set of the circumstances may warrant a violation. The enforcement discretion consideration, Part 209, Appendix A, require that the inspector consider and inherit the seriousness of the condition. For example, the track safety standards contents text is defective among the leading cause of the track caused by the accident nationwide is of the nature of particular defect, while the gauge of the particular dimension, substantial increase of the risk of accidents. The application of these criteria requires the inspector generally familiar with the leading cause of the accidents in his or her discipline consult the FRA Office of Safety Accident and Incident databases for more detailed information for accidents of a particular railroad. In addition, will the inherent hazardness posed of the defect of the enforcement discretion consideration all require the inspector to consider the factors present with the immediate factual situation that may exuberate or lessen the risk of serious consequences should be an accident and occur with the inherent hazard posed by the defect. The inspector must also consider the track owner's compliance history at this location. Repeated noncompliance and generally more deserving enforcement action is rare non-compliant condition. Some examples, criteria consideration when making a decision whether or not to recommend civil penalty include passenger trains, hazard material, population density, urban or residential area, speed, tonnage, involvement in the bridge or bridge approach, proximity to schools or highway grade crossings, compliance, accident history, potential negative environmental impact, strategic railway corridor network or STRACnet route. A violation should stress the importance of violation in light of the immediate circumstances as well as inherent pose of the condition. As discussed above, each of the inspector must exercise good professional judgment, weighing the enforcement with the discretion and criteria when deciding whether the recommendation of violation. However, the inspector must exercise discretion on the behalf of the agency, not his or her personal discretion. Accordingly, the inspector exercising the discretion is subject to a supervisory review. Moreover, an agency, the FRA has a duty to guide the exercising of the discretion when necessary, and authority with the exercise of the discretion above the level of the individual inspector, ensure properly forced enforcement, important compliance problems. In determining what instances of noncompliance merit permanently recommendation of the inspectors, consider the Title 49 CFR Part 209 Appendix A. 1. The inherent seriousness of the condition of action. 2. The condition of the degree of the potential safety hazard that the condition action possesses in light of the immediate factual situation. 3. The actual harm to the personal property already caused by the condition in action. 4. Offending personnel, railroad or individual general level current compliance as revealed with the inspector and as a whole, the personal recent history of the compliance with relevant set of regulations, especially specific location division of the railway involved. 6. When a remedy other than civil penalty ranging on the warning of up to an emergency order is inappropriate under all the facts. 7. Other factors immediate circumstances make relevant. Circumstances concerning the track safety standards most likely warrant the recommendation of civil penalties criteria listed below are generally application of the enforcement discretion applied with the common factual partners involving the defects and known to be leading the cause of the track cause accidents extremely persistent with the noncompliance, willing noncompliance, and also though that it is not possible to all circumstances must be likely to warrant a civil penalty. These conditions should result in the violation unless the track inspector determines special circumstances are present to indicate otherwise. Special circumstances may include immediate comprehensive remedial action for factors that lessen severity of the defects, dramatic reduction traffic volume, change in the railroad management, unless the inspector or the regional specialist agree on the circumstances dictate other civil penalties recommended for the following situations. When in the full follow-up of the inspection disclosed an unsatisfactory remedial action or no action was taken in condition, no compliance previously noted by the track inspector for the FRA or the track owner. This includes the automatic track inspection program's reinspection. System defects should have not been known before to the track owner as part of the pattern. The remedy with a similar substandard condition with the same and the subnamed division a subdivision, same yard, within the same supervisor's territory. For example, center crack and broken joint bar with the railroad knew when it should have known and existed or shown with specific evidence that is joint but the track segment that is excessive number of the center crack with the broken joint bars. For a situation, it may be appropriate to utilize a special notice of report, special notice for repair report. Multitude of defective conditions at the same location, joint and tied, defect with the center crack bar, geometry defective ties. In some case, the inspector should confer with the specialist to determine the civil penalties and penalties decided. A rail documented as defective in railroad, continuous rail flaw inspection with the absence of required remedial action. A broken out in railhead, they obviously existed since the last required rail inspection. Traffic defect caused by improper rails, deliberate installation of a joint bar that is not structurally sound, the design dimension on for the rail on which is applied failure to the drill holes in the rail ends and not complying with the track safety standards. Defective turnout of the ties with the poor supporting caused with the spring rail frog to excessive clearance between the hold down pausing of the horn. Note that including description of gouging contact outside the wheels against the gauge side of the wing rail. Excessively chipped of the worn switch points that are chipped and worn to present significant derail hazard. Any track or geometry defective clearly existed since it last required a railroad inspector. Therefore, the type of the defects do not comply with the designated class of the track and are found by an inspector. It is obviously that the railroad was not following due diligence in inspection of the track, in IEG constructive knowledge. A switch stand derailment can be thrown with a lock or hasp of the place. Non-compliance requirements is expected track. For example, the track on highway, railway, grid crossings does not meet Class 1 requirements with the railroad moving hazardous material, placard, and trains over the track. Listed above does not in any manner constitute an all-inclusive limit of the items that should be result in violation. However, the inspectors consistently address these situations, though enforcement action that will effectively focus on enforcement where it counts the most. It would be important for the capitalist in helping the industry make a significant reduction in the track-caused accidents. If no civil penalty recommendation occurs with any of the situations discussed above, discuss the specialist circumstance of the track specialist review necessary to achieve the responsible, uniform, consistency, and enforcement policy. Further, Chapter 2 for the instruction in preparing the violation of Form 6180-111. The regular cycle inspection notification forms 96. Reinspection of the best, most desirable means promoting compliance of requiring evidence. Deliberate noncompliance, take care of the site. And the same defects, original reported report recommendation. Civil penalty of the original report should include a background information supporting material found forwarded for legal action, in addition with an individual reference of each of the number original report. Complaint and accident investigation. If allegations of compliance with the FRA track safety standards is obtained during a complaint investigation, if consideration of the criteria discussed and indicates that it is the appropriate course, the violation report should be submitted. During an accident investigation in which the track condition and non-compliance with the FRA track safety standards determine the casual factor knowledge standards and can be satisfied, violation report must be submitted. In such situations, explain this clause visual relationship in detail with the cover memorandum noting the casual relationship recommendation. Aggravated penalty should be submitted to the office or the chief of the example counsel for the violation report. Special notice for repairs track class. Section 216.15 of Title 49 CFR deals with written notification issued to the railroad when the track does not comply with the requirements for the class in which it is being operated and is defined in track safety standards. The notice will describe the conditions requiring the track to be lowered in class, specifically exact location of the affected track segment, say of the highest class, corresponding maximum speed at which the train may operate over the track, the slower order remaining in effect until the repairs are completed. Consider the special notice for repairs in Form 6180. Lack of the violation compliance with the railroad. Section 213.5 holds the track owner liable violation of which the actual knowledge of the owner had the exercise reasonable care violation of whether it constructive knowledge whenever the circumstance of warning issuing a special notice for repairs may exist. Track inspectors are advised of the judicially decision making to seek a counsel with the respect of the regional specialist prior to the immediately after the special notice for repairs were practicable. If during the inspection, the track inspector determines the track does not comply with the requirements of track safety standards, makes every attempt to encourage the carrier to take the proper remedial action to correct the existing defects, track inspector should consider issuing a special notice for repair. The carrier refuses to appropriate remedial action for the defective conditions found by the track inspector that define the conditions to determine the pattern of noncompliance exists over the extended period of time. Observing evidence of the repeated violation which demonstrates the disregard of the comprehensive inspection and taking an approach and the remedial action. The inspector should evaluate the seriousness of the defects and determine with the existing defects present to the threat of safety. The inspector may issue the special notice for repair, requiring the carrier to reduce the minimum authorized operating speed over the affected track. The issuing of the special notice for repair to the carrier comply with the complete documentation. This will include the field measurements, the photograph location defects in relation with the known fixed point, and the written note narrative. A narrative will give the details concerning the track structure, and amount of the type of the rail traffic, what type of the condition is found. In addition, will note the condition of the defects throughout the inspection area. Furthermore, note the reaction response of the railroad, any other information that may affect the special notice for repair. Complete the special notice for repair in the field of the track. Description must indicate the track number, and other designations will specify the track with the order to comply. Location of the defects must indicate the reference to known and fixed point, mileposts, and road crossing switch, etc. Special notice for repair must be in written, personally presented by the appropriate career official. This eliminates the possibility of misinterpretation of information being received from someone who does not have authority or ability to carry out the provision of the notice. If the encountered delay of the situation, telephone warning can be used. They advise the railroad for the special notice for repairs to be used. The track specialist, the regional administrator, will be notified by phone as soon as possible. Less serious conditions that do not meet the requirements of track safety standards may not warrant the special notice for repair. Considering the determined seriousness of the condition, make up through the description of each of the defects of a special notice for repair for the following using the language of the track safety standards measurements made in the field. It may be exact, contain sufficient details, and describe each defect measure. Make the reference completed with the Form 96 at the time of the inspection. Section 213.15. Hold the track owner liable for violations that it would actually acknowledge would have known of the exercise responsibility, reasonable care, violation, and constructive knowledge. Compliance order and compliance agreements. General Instruction, Title 49, U.S. Standard Code 201111. FRA authority has the issuing of compliance warnings with the agency reasonable to believe the respondent of the engaging in the continuing pattern of the conduct of the installation involves the violation of the track safety standards procedures, issuing the compliance of the order found in Title 49 CFR Part 209 Subpart C. The compliance order normally will require remedial action necessary to ensure the compliance with the regulation, may impose the restriction of the compliance, and the achieved compliance order involving the track safety standards may include the requirement for the track owner to make so specified repairs by the specific deadline. The compliance order does not necessarily remove the track from the service. If the railroad does not comply with the terms of the order, the FRA may seek penalties of the violation of the order, seek enforcement of the order in a federal court. Procedures. If during the inspection the track inspector determined the railroad engaged in the continuing of the pattern of the conduct that involved the repeated violation of the track safety standards, the regional administrator through the track specialist should be notified. General guidelines determining that the continuing conduct patterns is follows. A number of inspection has been made. The inspection continued to relieve the defects and repeated non-compliance. The carrier refuses to bring the track to compliance with the standards. The inspector has made an attempt to have the carrier taken the remedial action through the actions such as the repeated inspection, submission, violation reports, meeting of the carrier officials, explaining serious and existing conditions, slow order through the use of special notice for repair is determined the regional administrative, the technical guidance track specialist. There's pattern repeated the non-compliance condition represented by the threat and the safety of consideration should be given the recommended issuance of the compliance order. The track division chief of the RRS 15, the Office of Safety Assurance Compliance of the Assistant Chief Counsel of Safety should be notified and consulted at this time. The recommendation containing the information noted below under the document must be forwarded to both of these offices. Complete documentation of the entire area must be developed, included with the regional administrative recommendation. The documented will include the following: location of all the defects, including measurement where required. This to be recorded on the track inspection form 96. The copy of the track inspection form 96 is to be relevant previous inspection at location. Copies of all relevant violation reports concerning the area in question. List of all the track caused and reported, both non-reportable, occurred during the previous 12 months. A copy of the carrier inspection reports of the previous 6 months. A written narrative should be prepared detailing but not limited to the following: amount of type of the rail traffic, the approximate tracks of home to schools and stores and etc., the carrier inspection maintenance programs and procedures, the seriousness of effects to the basis of determination if in the pattern of the compliance exists, details of each of the meeting held and the carrier officials, including date, names, and titles of those in attendance, and is discussed. Based on the information submitted by the Office of Safety Office, the Chief of the Council, decided whether the recommendation of the Administrator of the compliance with the order proceeding initiated with the Administrator approval of the Office of Chief of the Council when they issued the notice of the investigation based on the documented substitute submitted. If the railroad requests a hearing, the FRA hearing would be presided with over the trial type of the hearing, where the FRA would have the burden type of the providing factual allegation, reasonable remedial action sought. Here, officers cannot be applied with the administrative. The administrative decision can be changed in court. Anytime during the process, the FRA and the railroad could agree to the consent. The order present the administrator with a signature. The consent order will impose the requirements of the railroad on the railroad, concluding the litigation of the issue. In recent years, the FRA developed a simpler way of using compliance and order authority. Under the compliance agreement, the railroad agrees to take certain remedial actions should those actions not occur with the FRA's satisfaction. The railroad agrees not to oppose the issuance of compliance orders or emergency orders imposing those conditions, whether preparatory work necessary for the compliance agreement is substantial. So, emits the compliance order outlined above the agreement of the present FRA of the railroad for the certain advantages the FRA can obtain the remedial action quick and formal. If the terms and agreement are not met, the FRA in compliance and issue compliance order, the emergency order, and in the time of the expense of litigation for the form proceeding those. Therefore, the railroad achieves improved compliance without being subject to an actual order until it fails to meet the obligation under the agreement. In some agreements, the FRA waives the right to pursue civil penalties for specified violations if railroad meets all the conditions of the agreements. In other agreements, the railroad will pay civil penalties for extremely serious violation of the FRA may find while the agreement is in effect. The client can problems appear to the appropriate situation for such agreement. Regional managers should be contacted at RRS 15 or RCC 10. Emergency orders. Title 49 U.S. Standard Code 20104 for FRA has the authority to take special remedial action to handle emergency situations. If thorough testing, inspection, investigation, resource, FRA decides that an unsafe condition, practice, in combination unsafe condition practices cause an emergency situation involving hazardous death or personal injury, FRA may issue an emergency order that others may restriction and prohibit that may bring it necessary to bring the abatement of the emergency situation. The authority in such an order to rest the FRA administrator. Unlike the compliance order, the FRA may issue the emergency order without providing the opportunity for a hearing. The extraordinary power, accordingly, the FRA has used an additional sparingly issued only 22 orders from 1970 to 2000. Although statutes do not find emergency orders that must be present, the FRA to issue such an order. The FRA believes that if it refers to the condition excessively reprimands presents an imminent hazard of death or injury, the authority can be used if the conditions they were not compliant with the FRA rules and conditions are not used by those rules. General procedures. The FRA has the procedures issued for the track related to emergency in Title 49 CFR Part 216 Subpart C. The procedure requires that an track inspection defects an apparent emergency situation does not issue the notice of the track condition. The regional administrator then decides based on the notice with a recommendation. The FRA administrator in emergency ordered the removing of the tracks from the service. Those procedures also note that the administrator can also issue the emergency order with the following process. Ordinarily, in a true emergency, a cumbersome process is unexpectable. Therefore, it will leave to discretion of the region to determine the degree of urgency in the most urgent situation dispensing process set for 2000 Part 216. Inspectors who discovered an informed condition but the constituted emergency situation implemented contact with the regional officer during the inspection. If an apparent emergency is brought by the inspection attention, the emergency inspector should immediately inspect the alleged condition practice to determine whether the emergency situation exists. If during the inspection the inspector discovers an emergency situation that determines an inspection of the emergency does or may exist, the inspector may also immediately follow the procedures outlined in the chapter. The inspector has a doubt whether the condition or practice constitute an emergency. The factor may consult the track specialist. The track specialist should mediate association if there is a reasonable base for the alleged adversity allegation with alerting the regional administrator of the FRA headquarters of the situation. Regional administrator will keep the FRA advised. The track specialist may preliminary determine as whether the further the inspection is necessary. If allegation of emergency situation appears to have merit, the track specialist should contact the track owner immediately. Certain pertinent details possibly concerning the situation obtaining immediately voluntarily abatement prior to the inspection. The track specialist should assertion evaluate the steps, and if any the track indicates should be used to abate the danger, and the investigation should be conducted in accordance with procedure outlined in this chapter. Technical consideration. In determining the investigation has been made, the inspector thoroughly planned for the existing of the time permitted. The track specialist and inspector should review the known facts, deciding the technical equipment personnel may be necessary to conduct the inspection. Scheduling. An allegation of emergency situation received at the regional office, whether written or oral, must be handled as a high priority. Other commitments, weekends, holidays, leaves, and other consideration must not interfere with the expeditious or thoroughly handling of these cases. It's determined that these inspections should be made in the case it should be conducted at the earliest possible time. The extraordinary circumstances should be conducted in 24 hours to receive the preliminary evaluation of alleged emergency. Inspection. An inspection conducted because of the allegation of emergency situation. The alleged situation should be inspected first. The additional inspection activity should be placed on a solution of the emergency situation. The emergency situation has been resolved. The complete inspection of the facility may be conducted. Voluntary corrective action. As soon as it concludes the conditions existing with the constituting of the emergency situation, the inspector should attempt to have the situation immediately corrected with the voluntary corrective action by the carrier. The track owner or the representative of the owner should be promptly advised that the situation exists. The track owner ultimately resembles to determine the manner in which they correct the dangerous condition. When leaving the premises, the FRA or the state personnel must determine the emergency situation has been resolved and will not recur. Well, the track owner should be deemed to resolve an emergency situation if the element exposure to the situation, element, condition, practice that resulted in the situation. If the correction isn't taken voluntary, you should make an appropriate notation on the FRA track inspection report. Refusal to correct. If the condition is serious nature or not corrected, the inspector should immediately notify the regional office. Depending on the degree of the urgency, regional administrator will decide whether to proceed. It recommended the headquarters emergency order to be issued for that. The inspector notice the track condition appropriate railroad official, thus informing the carrier that the track does not comply with the requirements of track safety standards. Whichever route is chosen, the inspector will issue the track inspection report. The inspector has no authority to order or close down an operation, to direct employees to leaving an area in case of the imminent danger. His or her only authority is to inform the regional administrator in conditions observed, provided with the basis on the regional administration to take and make a recommendation of the FRA administration through an associated administration of safety. All right, the notice of track conditions. When the region decides the use of the notice of the track conditions, process set forth in Part 216 following the procedures must be followed. The notice shall set the describe and the detailed conditions found and specify the location, track number, and any other information necessary to properly describe the defects of the track involved. A copy of the notice of the track condition given to the carrier. The written narrative must be provided with the regional administrator with the 3 calendars of the issuance of the notice, and a copy of the notices will also be sent to the Office of the Associated Administrative Safety, attention RRS 15, as soon as possible. A written narrative complete documentation will include field measurements, photographs, location defects, reference to the known fixed point, details concerning the track structure, the amount of type of the rail traffic, not only on location of emergency order, but also through the entire inspection area, the reaction and response of the railroad, other information that may be effective to the order. The copy of the notice of the track condition shall be distributed as follows: original, first copy of the mail prompt to the track specialist, second copy retained by the inspector, last copy issued by the carrier representative. The track specialist will review the report and retain the first copy of the regional records and forward with the original Office of Safety Assurance and Compliance with the RRS 15. Information needed to support the issuance of the emergency order. The regional administrator consider the inspection report, input the track specialist, any material submitted with the railroad developing recommendation for the FRA administration. If the regional administration decides the emergency action is necessary, the recommendation should be supported to ample documentation, imminent hazard, safety hazard, previous attempt to address related safety issues of the particular railroad. The time of the permitting supporting documentation should include all the following information: general information required for the track inspection report for the Form 96 of the entire segment recommended for the emergency order showing the effect of the file, and during the inspection repetitive entries may be summarized in the sufficient number of the specified conditions and items are to portray an accurate view of the overall conditions. Previous inspection report served on the carrier of the particular line segment, including the returned report, should be corrective action, relevant violation report filed by the chief counsel, and the report number, the date and time of transmittal, the FRA case number if known, and the waiver investigation report if any, descriptive method of operation speeds, temporary and permanent, and copy of the timetable, special instructions, slow orders. Fact demonstrating the defective possess an imminent hazard of death or injury to the personnel. Automatic track inspection program data include a summary if and available narrative report of the discussion of the carrier's representative in chronological sequence, provides data on location, names and titles, number of the train, passenger through freight, local and category, annual tonnage, motive power employed on on low line maximum train lengths. Carrier imposed limitations on axles on particular equipment. Hazardous material information. Volumes of hazardous traffic over the line based on the view of the waybills consisting of the period of 2 to 4 weeks prior to the date of the investigation. Type of hazmat traffic. Illustrated limited listing of the recent hazmat data identified by the number of cars carrying explosive, poison gas, flammable, chlorine, and anhydrous ammonia, etc. Hazmat violation history on online is related to the derail risk, train placement, etc. Demographic information. Towns and cities along the line, name, the reference, the railroad, milepost, and approximate population. Illustrated description, including homes, schools, business, hospitals, etc., including proximity, the right-of-way, railroad, milepost, estimated number of the persons affected, including major highway, grade crossings, railroad bridges, over public streets, provided with the photographs showing the track in the foreground, area of potential at the risk of the background, and street maps if ready available. Topographical information, general description of the curve, the grades, provided the track charts, and if available, the railroad bridges, sharp drop-off adjacent of the right-of-ways, photographs as appropriate. Clearance with the reference of other active tracks of the structure along the right-of-way, the photograph as appropriate. Accident history. The railway equipment of the accident incident report for at least the past 6 months, regardless of the carrier's identification, cause attached line only. The FRA accident investigation report, if any, effective line only. Carrier internal reports of accidents, if not reported to the FRA. Special factors, abandonment of plans and status, if applicable, station agency with the interest of the rail service continuation, if applicable, plan rehabilitation efforts, if any, involvement in state inspection investigations, if any, press reports, competent completions of the public officials and other union officers, etc., and economic imposed proper order, only readable or available information, list of major industries online, with indication of hazmat traffic known and obtained from the railroad and likely effect of the order they will have on their business. Railroad response. The current information on the planned remedial action, adequacy response, projected completion data, resource, actual committed progress of the work date of the recommendation, the FRA, and actions needed to support the issuance of the emergency order. Inspector serves the notice of the track condition of the railroad representative. Note the regional administrator can choose to bypass this step and instead simply inform the railroad that he or she intends to recommend the issuance of an emergency order based on the inspection of the results. Regional administrator makes assignments of responsibility to complete the field investigation. The track specialist alerts the track division RRS 15 requesting assistance as needed, with the track division alerts for the assistant chief of the council safety. The track division RRS 15 assists the development of accident history information. The office of chief of the council and the office of secretary of assurance and compliance. The track division work together with the draft emergency order. The administrator issues an order. Whenever the emergency order has been issued for the FRA, the track specialist shall arrange the immediate makeup of the following investigation of determine with the track owner is complying with the return of the order of the regional administrative arranges to follow up the inspection as requested by the railroad to determine whether the conditions of lifting the order have been fully met on all portion of the line affected. Wherever the follow-up inspection indicates the relief from the order of the form is partially warranted, to the regional administrator notifies the RRS 15 and RCC 10. Those officers draft the field register notice necessary to grant the relief from the order. These procedures are intended to provide general guidance, and additional information may be required for some instances. If there is any delay of the development, any elements pertaining with the emergency order, such as typing the field reports, Office of Safety Assurance with Compliance and Track Division RRS 15 shall be consulted. Violation of the FRA emergency order of the FRA special notice for repair. When an inspector investigation, inspection, surveillance of the activity discloses the carrier involved that violated the provision of the FRA emergency order, the special notice for repair, the inspector will immediately report the circumstance of the violation of the regional administrator. The regional administrator will promptly transmit the information to the Associated Administrative Safety Office, the Chief and Council for advise to take action that should be taken with what information will be required to support the action. An emergency order special notice for repair violation report shall be made with the memorandum form. The subject and heading of the memorandum should be the violation report concerning the emergency order number, the fill number order in issued against, and file the name of the railroad violation report concerning special notice for repairs. Fill in the number of the notice issued against, fill in the name of the railroad or their track owner. The first paragraph of the memorandum report shall refer to the order and notice involved with provided with a brief summary and related to the circumstances of evidence to support the violation report in accordance with the advice and instruction provided by the Office of the Chief of the Council. Enforcement of safety laws and regulations against individuals. The further discussion of individual liability. See General 3, General Manual Part 3, Chapter 3. Under Title 49 U.S. Standard Code 21311, substantial criminal penalties may be applied to the individual companies who knowingly and willfully falsify records or purport records to be kept and submitted under the railroad safety laws. The track safety standards contains specific record-keeping requirements in Section 213-241 and specific reference to the criminal provision statute 213-15B. The knowingly and willfully standard essentially requires the government to be able to demonstrate that the person knew that what they were doing was wrong and did it anyway with the criminal intent. The government would need to be able to prove all elements if it in case of beyond a reasonable doubt because of the high standards of knowledge and the difficult burden of the proof. In such case, these are not easily to prosecute. Moreover, the failure to record track defects on the railroad inspection records is most often the result of incompetency, negligence, haste, and rather willfully conduct. Nevertheless, if any inspector has reason to believe that the railroad might purposely be falsifying inspection reports, the inspector should contact the regional staff and should notify the Office of Safety of Headquarters Office of Chief Counsel when appropriate. Those officers will necessarily referrals to request the criminal investigation. Chapter 5, Federal Railroad Administration Track Safety Compliance Manual. Chapter 5, Track Safety Classes 1 through 5.